We are starting now. Today is a 209th Friday group meeting. Topic is wrongful convictions and innocence claims, issues and challenges in India. The speaker is our beloved topmost IPS officer, Mr. G.K Goswami. So many degrees. In fact, I requested Aditya Giri will read full CV of sir. Otherwise, M.Sc, LLM, PhD, medicinal chemistry, PhD in law, D.Sc in forensic sciences and law. Aditya, now I request read sir's CV.
Yes.
Please take this.
Respected seniors and members of the bar, my name is Aditya Giri and today it is my privilege to introduce Dr. G.K Goswami, IPS, batch of 1997, who is founding director of the UP State Institute of Forensic Sciences, Lucknow, in the rank of Additional Director General of Police. In November 2020, Mr. Goswami has concluded the Fulbright Nehru Academic and Professional Fellowship as Flex Awardee from Cornell Law School, New York, on the Global Legal Challenge, Wrongful Conviction and Innocence Claim, which is also the topic of discussion today. Earlier on foreign deputations, he served as an expert on organized crimes in the UN, Office of Drugs and Crime, and had the opportunity to visit across the globe to share experience and views on wide spectrum of issues related to policing and law enforcement. Mr. Goswami, who has double PhD in law, D.Sc Forensic Science, is an avid writer, especially on exploring interface of law sciences, and has authored over 6 dozen articles in various journals of international and national repute. He has authored several books, including the latest titled Handbook of DNA of Forensic Application and Interpretation, which reflects various dimensions of DNA profiling in the courtroom, ensuring equitable justice. We welcome you, sir, today.
Thank you very much.
Sir, today, 2015, July 10th, we started our Friday group meeting. So, first 40, we don't have video recording, we don't have a camera. As we have our own channel in YouTube, that's YouTube Friday group channel. As on today, 14,18,486 views we have. 160 videos are available in one place. Subscribers 29,700. 160 videos are available. Now we request you to kindly address our gathering, sir. We are very happy.
Thank you very much, sir.
Now before that, sir, we'll present our Friday group 17th album.
Thank you, sir. Congratulations for this wonderful book. I will definitely give my comments and I will be benefited. So, good evening to one and all, and I am really grateful for inviting me to such a gathering, and particularly I am grateful to Sri G.Seshagiri Ravji, who is the founder of this Friday group, and seeing such a illustrious member of bar, it is my privilege to put my viewpoint on certain issues which I gathered through my journey of police officer as well as an academician. And academia is a kind of hobby or passion to me, and I will tell you in brief that how this developed over a period of time. I will divide my talk in 2 to 3 parts. Initially, I will tell you the role of forensic science, particularly how it may be useful for the purpose of advancing justice as corroborative evidence. What is its role? And I will give you the flip side also, that how forensic science can do blunder as well. Because as I always say, that science can do wonder, but the man behind science can do any wrong, right? So the procedural part is very important, and especially in the light of section 176 subsection 3 of the newly introduced Bharatiya Nagrik Suraksha Sanhita 223, which is going to be implemented from 1st July of this year. So now onwards, forensic science evidence will be compulsory or mandatory to collect in those cases especially where the punishment is 7 years or more. So now we have to learn about the nuances of forensic science. So this will be one part of my discussion. Secondly, although you being the defense lawyer, you bother about how the person may be acquitted or innocence may be proved. But let me tell you, rest of the actors of criminal justice system, including police, prosecution, we are very dedicated, we are always bothered that how conviction can be secured. Whether a person is really culprit or not is a question mark. But I generally say that police or prosecution, if they get, some conviction, then they generally clap, and otherwise they mourn. But I always feel that we should strive towards getting justice, right? It is not that anybody may be punished. So the purpose should be that right person should be punished, and the person who is innocent should never be punished, right? So that is one part of my discussion. Another point I want to discuss is the innocence issues, and that is very, very challenging. And how I developed this interest, I will tell you in the due course. So let me begin with the topic wrongful conviction and innocence claim, and particularly the role of forensics in all this justice system. Respected members, as you know all, that justice is the hallmark of the society. Everybody wants justice. That is it goes without saying. And to discover justice or to find out justice, you need to have truth behind the facts, right? But both justice as well as truth, they are difficult to determine, right? They are not tangible, they are intangible. So their quantification is very difficult. So it is the evidence basically which give them tangibility. So evidence becomes most important part when you really want to deliver justice, right? That is most important part. Most of the time we are dependent on oral testimony, be it a eyewitness, an eyewitness or any other oral testimony. And all we know that how oral testimony may be defective. There may be challenges altogether. I need not to express more. So we need to have some corroborative, evidence. Even if a person, you may be very sure that he is telling the correct things, even then, for the purpose of corroboration, it is most important part for all of us that whatever we are taking as a incriminating evidence, it should be pure and verified. So forensic science can be a very good tool for the purpose of corroboration. So this is one part how forensic science is important. The another beauty of forensic evidence is that they are neutral. Most of the time we divide, especially in the adversarial system, that one side the prosecution tell their own story. They are taking one side. Or contrary to it, defense take its own side. So there is not a level playing field, right? This is a big problem. But forensic science is a neutral evidence. It does not take any side. Secondly, it is scientifically proved facts. They can be repeated. Like suppose if you have any doubt on DNA testing or DNA report, you can go for repetition. So they can be retested. They can be retested in any other lab as well. So their purity, their probity is more so compared to any other evidence. But there are different and very tested issues which have been found across the globe, and there are frauds and all in forensic domain also. We have to be very careful and cautious, particularly about the procedure. You must be aware about the Anokhilal case, which have been recently dealt with in the same court where we are sitting here. And recently, I will tell you in little detail the Anokhilal case, which is an eye-opener case, and we can start with the Innocence project in India in the light of that case. The important issue with that case, in the same court here we are sitting, on 18th December 2019, That case was basically referred from lower court to high court for reference for confirmation of death penalty. High court also confirmed the death penalty, and then ultimately our own bar member here, the advocate Siddharth Luthra, was the amicus curiae, and the court has remanded that case particularly for retrial, de novo retrial. But again, the second trial, the clear-cut order were not exactly followed, and again the poor chap was awarded death penalty, the second time in Khandwa district court, right? And then again it went for as reference for confirmation, because this time Honorable High Court was very cautious. They took it letter and spirit, they obey the Supreme Court order, and they again sent the case back to retrial. And then on 19th March 2024, the poor chap got acquitted, right? Here I want to tell you two another important terminology. One is acquittal and another is exoneration. The fine difference between the two terminologies. Normally we use term acquittal, hardly we use exoneration, right? Although in English parlance, in the dictionary meaning, they look similar, but in legal parlance they are little different. Acquittal generally we adduce when we do not have any confirmation whether the person is ab initio innocent or not. We do not say that the person is innocent per se, right? Because there are not sufficient evidence to convict, that is why we use term acquittal. But exoneration is certainty that yes, we have tested that this person has not committed the crime. So exoneration actually washes out the total scar on the character of a person. But we do not have that kind of system. US, UK and many other countries has that. I will tell you how it was developed and all, right? So this is one thing, and particularly the forensic evidence are very, very important. I want to say that these tools, this beauty of forensic science should be utilized as much as possible. But we will discuss little bit about the forensic fraud and other things with the due course. So this is one part. Now I tell you the story how this developed to my mind about the innocence claims and all. Basically I was here, I did my PhD from JNU, and I was in life sciences school, and one of our colleagues sitting here was my I think contemporary in JNU at that point of time, he mentioned just now. So my research was on DNA, right, and many other things, and fortunately the faculty those days in late 90s were the world-class faculty. So I did my research, then joined this service and all, and I almost did not have direct access to all these things. But when I joined as ASP in Varanasi, it was as early as I think 97 or 98. There was one case which was very famous case, and in 2014 that was celebrated case on DNA decided by Honorable Supreme Court here. That case was one lady from Netherlands, age about 21, 22. She was a tourist to Varanasi. I was ASP, just landed after completing my training, and that event happened in the month of June 10 to 1998. The girl was very simple girl, very very simple, dedicated and all. She just was staying in one hotel, and as usual one rickshawala was carrying her for different places in Varanasi, and he got acquainted with that girl just, and one day he said that, look, if you want to come to village, I will take you to my village and I will show how the rural background here and how the folk lives there. She was a very simple girl and she was agreed. She went to Gazipur, and for various reasons, whatever it is, there were certain areas which I don't want to mention, but ultimately the girl was killed and was buried under the inside a room, and there was the floor was the proper flooring with cement and all was covered, right? the girl was missing, nobody was knowing. Those days, these mobile phones and all facilities were not there, of course. So poor parents, when she could not contact it for 3-4 days, 5 days, then they were worried. They contacted the hotel and all. They also confirmed, yes, the girl is missing since last 3-4 days without any information, right? Ultimately, cutting the story short, that boy was caught because rickshaw puller and all people say that he was carrying the girl most of the time, and the dead body was recovered. By then the petrification and everything was done. I think by then most of the evidence were being collected, but when I reached there as young ASP, I was having full idea about DNA forensics because it was a very new technique those days. And if few of you may be aware about Dr. Lalji Singh, who is a pioneer person in DNA forensics in India, he was that time in CCMB Hyderabad, and I was aware of that technique. We requested him for conducting DNA test, and that case became a renowned case of India, the first case on DNA, and that helped to connect the parents with the daughter. Otherwise with bone it was difficult, although earlier the skull superimposition and many other techniques were used, but DNA was very well used, and in 2014 it was well appreciated. And those who have some interest, S.K. Yadav versus State of UP 2014 Supreme Court case. So that is how DNA was introduced. So since then, because I am a police officer, I have seen police very closely, because UP is a place where you have so many chances to see things from different corners. So I have fair feeling that lot of innocent people get implicated, and sometimes there are fair chances that they may be even convicted because of false oral testimony. So I had that feeling. When I did my research and I came to ILI and all, and those days Andy Tiwari case was also in limelight, so I present my case study in ILI, and also I developed even more interest in DNA forensics and all, right? And later I got opportunity for research, and also I find it very strong tool that DNA can be used in very well founded manner. Now I tell you another story and my own research, just to give you some kind of glimpse. If you see the statistics of our crime, and particularly the rape figures, I have the presentation, but I will just give you the sense of that. That nearly in rape incidents in India, the police file charge sheet in about 90% cases, roughly 93, sometime maybe 88 or so, roughly 90% cases. But conviction rate is nearly 30% in rape cases. So this 60% gap is a very, very big challenge. My research of PhD says that if you conduct three important, evidence collection, one is medical legal report. Most of the time in POXO cases and all, there are fair chances of getting some medical legal injuries and all. That is one. Second is if 164 statement before the magistrate is positive, which most of the cases it is positive, and if you conduct DNA test, and if DNA test is positive, then this figure from 30 jump to almost 100%. That means if your 164 report before magistrate statement is positive, your medical legal is positive, and your DNA is positive, then you will get 100% results. Okay. So only thing is to conduct DNA, because both other evidence collection is done by police. And this same scenario is by and large in POXO and many other cases. And you will surprise that not only in body offense, but DNA can be used even for other kind of cases also. In non-human DNA also, we can collect samples from non-human also, dye atoms and many other kind of plants and all, and there are reported cases. So DNA has its own benefit to utilize. Okay, so this is point one, how you can use DNA and other techniques for the purpose of flawless justice, I must say. So that the chances of miscarriage of justice is minimized in your judgments. So that is the strength of forensic science. Now let me come to innocence claims and the wrongful conviction, one can say. This problem was existing across the globe. It is not only in India. I tell you one example, then I think it will be more sensitization. In 1660, near England, the suburb of England, there was a person, Richard William. He was about 70-year-old, and he went in the evening to collect rent from the neighboring village. He must have some house or something, and he went out. He did not turn up. The worried wife sent her 12-year-old servant named Perry to search the old man. Right? He also did not came back. Then his son also went out to find out the father, but they got only two things. One was his scarf, the muffler type, and another was the hat, and having some red color disguising with blood. So ultimately they felt that probably William had been killed, and the doubt went to Perry. So Perry, his 14-year brother, elder brother, the younger Perry was of 12 years, elder one was 14 years, and mother. They were being suspected, investigated, charge-sheeted, and ultimately they were being hanged. And I tell you, sir and madams, that in US, in many states, and particularly Alabama, if you see, hanging is very frequent. We are lucky that way, that in our country, for various reasons, hanging is not a very, frequent phenomena. But US, it has a big problem. So they were being hanged. The matter was ended, but it does not. After about 1.5 years, Mr. William came back. He returned. Now the entire judicial system was on stake. So this creates a lot of hue and cry. And if you remember, one doctrine of law, that is corpus delicti. The corpus delicti doctrine was invented after this case only. So such type of cases were rampant. And one person who contributed a lot was, his name I just forgot, but in 1913 onwards, his writings has indicated lot of incidents where wrongful conviction was there, but somehow or other, people were bypassing those kind of claims, that like in thousand cases, if there is only one or two cases, then they have to be ignored, right? So nobody paid any attention until and unless DNA was discovered. And I tell you the story of DNA, how DNA was discovered. This will also sensitize to greater extent the role of DNA. I give you in brief, just in 4-5 minutes, because time is rushing. In late 1970s, one geneticist named Dr. Alex Jeffrey, he was from the Lancaster University of London. He was actually researching on a topic that how parents can be connected with the children genetically, that meaning thereby whether pedigree can be set up by way of analyzing any genetic material. So genetic connectivity between the parents and children, this was the research question. And precisely on 10th of September 1984, they got the desired result. They called it Eureka movement, and their research was successful. And they termed that research or their finding DNA fingerprinting. Why? Because DNA was genetic material, and fingerprinting is considered to be the unique identifier. So DNA became unique identifier for human identification. So this was one landmark in the annal of DNA fingerprinting. This research was publicized across the globe. It was a huge attention it drew across country, and people were very amazed with this kind of connectivity. In 1985, one incident happened which again brought DNA into courtroom procedure. The incident was like this. One Ghanaian lady was struggling before immigration authorities to immigrate one of her child, age about 3 years. One another child, elder child, was living with her in London, but she wanted to bring the another child from Ghana. The authorities were having doubt, thinking that the child does not belong to her, and she is in disguising as a mother, want to bring her illegally. So this legal issue was pending. Having known the research by Alex Jeffrey, the advocate of Ghanaian lady requested the authority that the same research has been done in our own city. Can't we utilize that advantage of that research for connecting or to find out whether the child belonged to the mother or not? Authorities accepted this proposal. Alex Jeffrey was brought in. He collected the biological sample of mother children, both of the children, and the research, the analysis of that blood sample finally settled the dispute. And Alex Jeffrey has written in his own biography that when he announced the result in the courtroom of the immigration authority, and when he said that the child belongs to the mother, so he writes that the look, the gaze, the gratitude the lady has towards him, he said that I have never get that kind of reward to my research. So dear sir and ma'am, I want to say that if you deliver justice to anybody, the kind of blessings you get from them is immense. So this is number 2, and this way, this was the first knocking the door of justice system by DNA. The third and important part really was in 1996. There were 2 incidents of rape and murder of very adolescent girls, 2 different incidents of 1983 and 1986. 2 girls were raped and killed almost in identical manner, with the same modus operandi. And the distance between both incidents was almost stone throw, maybe 30-40 meters. They were both cold cases, having no clue. And both cases were being detected by a detective, English detective, David Baker. And he could not get any clue. Anyhow, he caught one fellow named Richard Buckland. At that time his age was 17, and somehow or other he accepted to commit the second crime of 1986. But when he was placed before honorable judge for trial or whatever reason, judge asked certain questions and judge was not happy, judge was not satisfied. So he said, look, the evidence are not enough, you please investigate further. But doubt, or you can say cloud of doubts, were still hanging on the head of Buckland. When there was no clue, then Baker thought that let me just ask Alex Jeffrey whether he can help us to detect this case. He went to him because Alex Jeffrey was very much excited with his research and his intervention into justice system. In fact, I keep talking to Alex Jeffrey and he narrated all these things by his own. So that is how I came to know many facts which are not being written in any book otherwise. So he said that I was very excited that if something I can do for justice system will be a great help for my research. So when they examined or they calculated the prospective rapist in the area when they had some kind of survey. There were more than 5,500 odd cases that they have to be analyzed. And you know, till date, DNA technique is considered to be very costly. So huge amount has to be spent if you want to conduct those numbers of examination by DNA. So the budget was required. Matter went up to the then Prime Minister, British Prime Minister Margaret Thatcher. And believe me that British Parliament sanctioned special budget for that purpose. That is why I always say that they actually take chance, and that is why they discover. Anyway, the budget was allotted, the sample were started. First case was the Richard Buckland, poor chap. So his sample was collected, and interestingly, DNA gave clean chit to him. So first of all, DNA proved innocence of a person. So that was the first case reported where innocence of a person was proved by DNA. Now the sample started collecting, and in nearly 5 to 6 months, around 5,000 people were screened, but no result, no positive result. It was very disgusting to them. And one incident happened which was a landmark and changed the landscape completely. In the evening, in a pub, a person called Jan Kelly was sitting, chatting with the friend, and he disclosed a fact. He said that, look, one of my friend has requested me to disguise or impersonify in the name of him and to submit the blood sample. And mind that he successfully did it. He went, gave sample in his friend's name. This talk was overheard by the person who was serving there, and it was passed on to police. Police caught Jan Kelly. Jan Kelly disclosed that it was pitchfork. When pitchfork was caught, the blood sample was collected, and analysis disclosed that this man is involved in both the cases. So the correct right, or you can say the person who has actually committed the crime was brought to the court. And one another disclosure here very important, that this man, this Colin Pitchfork, he was a serial or recidivist. He has done more than 50 reported cases of the same kind. The sexual harassment, rape, and many others. And he was living hardly 300 or 400 meters from the place of occurrence of those incidents. So you can conclude with this that police, sometime, whether it is American police, British police, DNA was, you can say, spectacularly enter into criminal court. And later it has proved in a very significant manner. So I want to highlight that DNA proved both the innocence as well as guilt in a equitable manner. So if you have conducted any DNA test or any forensic science in a correct manner, that will help you in a very, very big manner. So this is one important point I want to mention.
2022, sir. 2022.
Now I want to give you one important another point why human identification is important. Human identification is very important, sir and ma'am, because if you see, the total investigation hinges upon human identification. For victim side, if you see, if a person is dead, then you have to find the identity, whether who is the person. If a person may be mentally challenged, then again maybe a toddler or may not be having a condition to speak. So victim side also you have to identify a person correctly. Equally on the accused side, even if an accused is named in FIR, or it may be a cold case having no clue, you have to prove the identity of a person without any doubt, beyond any reasonable doubt. So human identification is a crux. And forensic science per se, they help you for correct identification of human beings. So this is the crux of my talk till now. Okay. And I just read one important observation of Alex Jeffrey, what he said. I am pretty sure that given his confession, Buckland would still be in jail today. And you all know how police works, that probably if this disclosure by DNA was not correctly being done, by collecting one evidence or other, ultimately Buckland would have been booked and he might be even convicted. So he rightly said this. And on the strength of DNA, Justice Joseph Harris of US Court in People versus Wesley case has noted, DNA technology could be the greatest single advance in the search for truth, conviction of the guilty and acquittal of the innocent since the advent of cross-examination. So this is a very, very powerful statement in the favor of forensic, you can say, DNA. Now, inspired by this whole DNA business, right? Two advocates like you are sitting in the middle age, and I had opportunity to be blessed by both these gentlemen when I was in US in 2022 for this project. Barry Sack and another fellow was Peter Newfield. They were young advocates and they were very overwhelmed by the power of DNA for identifying the correct guilty persons. And they introduced one project called Innocence Project. And they, Barry Sack told me, because he was my mentor in US and he's a very celebrated guy because now he's about 75 or 72 years old. So he said that initially the entire judicial system was opposing them because they say that now we have reached to finality. We have concluded the case up to appeal. How can we open such type of cases? But 2-3 more cases have the important incidents happen. I will just mention that before I talk about Innocence Project. One case is also important, the Sam Shepard case. Sam Shepard case I just brief in 2-3 sentences. In 1954 in Ohio, a medico couple was staying called Sam Shepard and Merlin Shepard. Both were doctors, and they were having a 7 or 6 to 7 year old boy called Sam Shepard, Johan Shepard. One morning, the lady was found brutally killed in the home. As usual, poor husband was caught, and ultimately he was booked, and media was badly, actually they have badly reported, and I will tell you the observation of Sam Shepard case. Media has, a federal judge criticized the media. If ever there was a trial by newspaper, this is a perfect example, the Sam Shepard case. Newspaper took up itself the role of accuser, judge and jury. So we also know in India that many a times the media trial also influence very greatly the investigation, trial and every aspect of justice system. So that is very, very sad. So this person was ultimately acquitted. There is a story, you can read it in the Google or something. But what happens, he was very much disgusted. He was a doctor, and those point of time there was a research for anti-cancer drugs. So he volunteered saying that you can use me as a test animal, and he took over all those medicines, and ultimately he suffered with cancer and subsequently died in 1966. Okay. When DNA came into courtroom and proved its worth as a powerful tool for finding innocence and guilt, his son was by then elder, he was a young gentleman. He also requested the authorities that please conduct DNA on my father's case. And the best part, in US, UK and many other countries, they were preserving the samples for nearly in some states 70 years, some state 50 years and so. So their artifacts were being preserved. And when they conduct DNA, it proved that Sam was not the culprit. So actually he could wash out the, you can say, the blame on his father posthumously. So DNA became very powerful tool, and ultimately there were many other cases which I must mention. One another is O.J. Simpson case. O.J. Simpson, probably few of you may be aware, and if you have not, then please just have a look. It's a very interesting case, how DNA was challenged and many other things. It is called trial of the century. It's a very, very famous case, O.J. Simpson case. It was paucity of time, I will just skip this part and I will come to Anokhilal case. I think this is an important case for us to take some note. And before that, Innocence project, they introduced this concept actually, and by now they have nearly more than 3,500 cases, by which not only people of conviction but people on death row, they have been exonerated. And I got opportunity to interview 12 people, those who were on death row at some point of time. And one person was, he served 31 years in jail, and his execution date were fixed for 3 times. But fortunately for technical reasons it was not executed. And ultimately DNA and other techniques proved that he was innocent. And lively I interviewed him. So I was thinking that suppose this DNA was not there, he could have been gone since long. So that is the beauty of DNA. In Anokhilal case, as I mentioned, that briefly speaking, in 13 days, the investigation was complete in blind rape case of 9-year-old girl, right? In next 18 or 19 days, the trial was concluded. Total 33 days were there, right from the day the incident happened and the judgment by the trial court. 33 days, okay? And DNA report came only when the 313 stage was crossed. The legal aid was provided when the 313 was also over. And it was written in the order that the accused has refused to give any kind of defense. Can anybody believe this? That the rape accused will say that I don't want to put any defense. So how casually it was taken. And ultimately he was being awarded death penalty in 31 days. Right? Then as I mentioned that in 3 months, High Court also confirmed. Here the point which I want to mention, that probably everybody of us knows that delayed justice, denied justice. But this case proved that hurried justice, buried justice. So we should be very, very careful and cautious when we do such type of things. And if we see the reason for wrongful conviction, although in our country confession is not a very problematic area, because confession before police is not admissible until unless recovery under 27 section recovery. But in US, confession is taken as a gospel truth. And this is a big problem. And they say, because I did my research on this point, they say that we think that right to self-determination is very strong in US. Why people will say I have confessed, and mind me, I have visited their interrogation room. And the interrogation room is so harrowing. I thought that if they keep me for 1 hour in that room, I will also say whatever they say. So confession should not be, and confession is a big problem, right? So confession is one. Then the guilty plea. Guilty plea is also a kind of very debatable issue. I don't know how you take it up. And in India, a lot of advocacy is coming up, but I think we should take up guilty plea with very cautious manner. And one another disclosure I want, although it is not a disclosure, it is a known fact to everybody, that in US, nearly 94.5% cases, and conviction rather, are based on either confession or guilty plea. So there are hardly trials. Only 5% cases go for trial. So confession based, and that is the biggest problem there. So don't think that criminal justice system in US is very hunky-dory. I have otherwise feeling there. So these things, although we have lot of challenges in our own system, but at least those kind of challenge we do not have. We have different type of challenge, but note that. Now, before I conclude, let me just give you the flip side of forensic science, because you must know we are actually my own institute, which we have founded very recently, is taking up forensic science with law, and this is the only institute in the globe, I am not saying India, which has merged forensic science with law. I have a strong reason to believe that forensic science without law is incomplete. Likewise, legal studies without giving proper understanding of forensic science will also be incomplete. So there has to be a fusion, and we are trying to bridge this gap, and we will be shortly introducing certain courses by which we will be providing the necessary inputs to the legal fraternity. So those courses will be online, and we can be benefited by that. In forensic science, the problem are multifold, but few I will just give you example. One is dry labbing. What is dry labbing? Dry labbing means without conducting any test, the report is being submitted. And don't mind it is only with forensic science. We all have faced these type of reports during COVID. Lot of reports were being submitted or being provided by the laboratories without conducting any test. So forensic science also suffer with this, and this is not only a presumptive theory. These type of things have been proved in US. US has examined such type of problems. Forensic frauds have been identified. In Houston lab, I was there for about 10 days. In those days, that lab was considered worst lab in the United States. It was published in New York Times, and now it is the best lab. So forensic fraud is a big problem. Here in our same High Court, the same Delhi High Court, one important case of 2018 is Khurshid versus State of Delhi. In that case, it was POXO case. The victim was 7-8-year-old child, and the penetrative sexual assault, of course, and all evidence were cryingly saying or indicating that accused is a culprit. But because DNA was clean, that is why, relying upon DNA report, not only the trial court but even Honorable High Court also acquitted. And these three cases in row, they were of same nature and the same bench. By chance it was in the same bench. When fourth case came, Khurshid, court was very surprised that how these type of things are happening. And the silver line, or you can say the important point I think they observed was that the report was constructed by the same expert. So they have some doubt. And then they order for conducting DNA by the separate lab. When the new report came, it was implicated, or the report was incriminating against the accused. And when other three cases were also re-examined by DNA experts in different lab, the report was reversed. So such type of frauds do exist. So my request to you is that whenever you deal with DNA, you please examine the procedure. Whether procedure has been, what we do, we generally read the concluding para, right? Don't go with the operative para. Find out the metadata. How you reach to this conclusion. Another problem with the forensic science is that even the forensic expert has not been defined, neither in section 45 of the Evidence Act and the corresponding 39 section. And I am as a researcher, my observation, and not only my observation, anybody can see it, that only one word has been introduced in forensic legal framework in the new Sahita, is the signature word had been introduced. Otherwise, rest of the things remain replica completely. So I think that part has to be done. At least the definition of expert is needed, because if you have not been defined it, then there is a conundrum continuing in the system. Only the good point which I mentioned in the initial, that DNA, forensic science power has been recognized, and now forensic science evidence will be mandatory. But we have to build capacity in a large manner. So with this, now I conclude because almost I completed nearly 50 minutes time. Although lot of things could have been talked, but I know the limitation of time and all. So thank you once again very much for giving me this opportunity and with very patient listening. Thank you once again. Thank you very much.
Thank you very much, sir. You have given very valuable inputs to your
Thank you,
today's
sir.
topic. You came all the way. We are highly grateful to you.
Thank you, sir.
Like Government of India, the way they give Bharat Ratna, Friday group hardly we have anything.
नहीं सर दीदी भारत रत्न बोल
We'll give a standing ovation, sir, on behalf of Friday
नहीं
group.
सर
I
thank you
request.
thank you so kind of you. Thank you. Go back for me. I always say that I came here as a police officer to this court, then for ILI as a student, and today is my third intervention as the speaker to this August House. So I am really grateful and very much enthusiastic for this. Thank you very much.
Now I request Vidya Vijay Singh Power will give you a vote of thanks. Please Vidya, sit down. Please sit down.
Yes.
You go.
On behalf of this Friday group, I, Vidya Pawar, thank you to you, sir, kindly inviting, accepting the invitation of the Friday group and giving us this valuable inputs to this Friday group. And on behalf of all this August gathering and online and offline people who are watching this online recording of this Friday group. So I'm thank you to you, and on behalf of the Sheshu sir also I thanks to you, and thank you Sheshu sir for giving me opportunity, and thank you Sheshu sir for inviting sir to give this valuable input to us on this important topic on criminal justice system, innocence and acquittals of this person who are convictions due to this help of the forensic science. Thank you everyone.
Thank you.